Welcome everyone to the University of New Mexico Law Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This is a weekly series run by the Division of Forensic Behavioral Sciences of the University of New Mexico in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo. I'm the Forensic Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenters, you can enter those in the Q&A box anytime you feel comfortable. Do know that we hold questions until the end, and oftentimes it's not possible for us to get through all of them. If you are pursuing continuing medical education credits, there is a sign-in sheet in the chat box now that you can access to receive those credits. If you are pursuing APA continuing education credits, there will be a link in the chat box for you to open, but that will be near the end of the hour. So keep your eye on that chat box near the latter points of the presentation. There will be a link to a survey that you can complete for a CEU credit. Make sure that you open, bookmark, otherwise save that link before the webinar closes, and make sure you save a copy of the certificate of completion after you complete the survey. If you missed last week's talk in the series, Dr. Ira Packer's discussion of hospitalization assessments in competency evaluations is now available on our YouTube channel. The recording for this week's talk will also be available on our YouTube channel sometime later this week, and a version of PowerPoint slides for those that have registered for the series will be available later this week as well. As a heads up, next week we have Dr. Susan Hatters-Friedman, who will be discussing public health issues regarding maternal filicide. But circling back this week, I'm excited to introduce you to today's panel of speakers who will be discussing competency evaluations in Washington State. I will go through these introductions one by one right now. First, we have Dr. Leeza Rojas, who is a forensic evaluator with the Office of Forensic Mental Health Services in Washington State, where she conducts competency evaluations with the outpatient team and recently completed her forensic psychology postdoctoral fellowship there. Dr. Rojas earned her doctoral degree from the Graduate School of Professional Psychology at the University of Denver, specializing in Latine Psychology and working with forensic populations in a number of settings. We have Dr. Sierra Stillwater, who is also employed by the Office of Forensic Mental Health Services and completes inpatient competency to stand trial evaluations there, having also recently completed her forensic psychology postdoctoral fellowship at the Office of Forensic Mental Health Services. She earned her PsyD in clinical psychology from Alliant International University, San Diego, and is a licensed psychologist and forensic evaluator in Washington. Dr. Jasmine Raysor is currently a forensic psychology postdoctoral fellow at the Washington Office of Forensic Mental Health Services. She earned her master's in forensic psychology from George Washington University and her PsyD in clinical psychology from Loyola University, Maryland. She completed her doctoral internship on the forensic track at South Florida State Hospital. Dr. Sanam Monjazeb is also currently a forensic psychology postdoctoral fellow at the Office of Forensic Mental Health Services. She completed her PhD in clinical psychology with a forensic concentration at Simon Fraser University and her internship in the forensic psychology track at Patton State Hospital. Lastly, they are joined by Dr. Jacqueline Means, who's a licensed psychologist and training director for the Forensic Fellowship at the Office of Forensic Mental Health Services. I also had the pleasure of hearing her and her team discuss some of these issues of competency evaluations in Washington State and the unique considerations they've had to go through at the APLS conference in 2024. So everybody, on behalf of the University of New Mexico, thank you again so much for taking the time out and joining us and sharing your expertise and unique perspectives with us today on competency evaluations. I'll go ahead and toss it over to you.
Thank you for that welcome. We are happy to be here today to talk about how active litigation has really affected our mental health system and how the default mental health system of requesting competency evaluations and housing individuals in the jail setting has impacted and shifted our service as forensic evaluators. So today, our interests are as state employees, and we do not have any financial holdings or agreements related to the content within here. We are employees of the state and provide objective evaluations to the court systems here in Washington State. And our primary objectives today is really going to give you an overview, a brief primer on how our landscape for completing competency evaluations has shifted over time. I've been here for the last going on 13 years. And so I've been here through the full breadth of the shifts and adjustments and readjustments that we've had in response to both the growing need for mental health services in the forensic system, as well as responses to the active litigation and the negotiations that go along with that. So I am going to hand it off to Dr. Raysor to start in on that content.
Thank you so much for the handoff, Dr. Means. To start off our presentation about competency in Washington today, we first wanted to provide some background and review some of the basics. All criminal defendants have a constitutional right to assist in their own defense. If there's reason to believe that a defendant may not be able to do that due to a mental health condition, the court will typically put their case on hold while an evaluation is completed to determine whether a defendant is competent to proceed or not. Typically, if a defendant is found competent, they are able to continue with court proceedings and to stand trial. If the defendant, on the other hand, is found incompetent to proceed, they may be ordered to receive competency restoration services and be reevaluated after a period of restoration, or their charges may be dismissed. The Department of Social and Health Services, DSHS, is the umbrella organization that all of us at the Office of Forensic Mental Health Services are under, and is the state agency in Washington that provides competency services. Not to sound like an alarmist, but there is a national crisis when it comes to competency, meaning that the rates of competency evaluation orders have increased significantly in recent years. And this is something that we've seen in the data. Between 2013 and 2023, the numbers of orders in Washington increased by about 183%. And in states like Virginia and Colorado, the numbers of orders increased by up to 275% within similar timeframes. We're also seeing the proportion of defendants being found incompetent increase. The average rate between 1960 and 2009 was estimated to be about 27.5%. But more recent estimates suggest that the number of defendants being found incompetent is somewhere between 30 and 50%. Individual evaluators are also experiencing increased caseloads and pressures from courts and attorneys. But despite this increase in referrals, forensic evaluators still have a duty to create quality products and reports that help judges and the finders of facts come to their decisions. As seen in this graph here, the average number of competency evaluation referrals in Washington state has been continuously increasing since 2013, with the exception of a dip in referrals that we see during the height of the pandemic for COVID-19. We also see on that bottom line there that the number of competency restoration referrals, which includes inpatient admissions to state hospitals or other competency restoration facilities, and our outpatient competency restoration program, has also increased since 2013, but at a slower rate. In this chart here, we can see the staggering number of orders received for jail-based and inpatient evaluations and for inpatient restoration. Similarly to the last chart, we see that numbers have increased consistently, excluding once again around the time of the COVID-19 pandemic. In July of 2019, a law change occurred, making it so that defendants in Washington who were charged with misdemeanor crimes and found not competent could have their charges dismissed and potentially be evaluated to determine if civil commitment was appropriate, unless the prosecutor objected to the dismissal and proved that there was a compelling state interest in ordering competency restoration. So in this chart here, we see the average annual number of restoration orders for defendants with misdemeanors across fiscal years, both before and after that law change. So once again, we're seeing steady increase, excluding the COVID-19 pandemic. So now that we've looked at the numbers, let's start talking about Trueblood and Washington State. Trueblood was the class action lawsuit that was filed on behalf of defendants who were court ordered to receive jail-based or hospital-based competency evaluations or restoration services. The suit argued that defendants' 14th Amendment rights to due process were being violated due to the length of time it was taking for defendants to receive services. This suit was not unique, as there were similar lawsuits filed in other states like Alabama, California, Colorado, Oregon, Pennsylvania, Texas, and Utah. As an overview of the timeline, the state was sued in 2014, found liable in 2015, found in contempt for continued noncompliance and fined over $83 million in 2017, and were able to reach a settlement that outlined preliminary solutions in 2018. Since that time, the state has worked to provide resources to address the referral rates for competency-related services and to reduce the number of people ordered to receive these services. Although the Trueblood lawsuit was not officially filed until 2014, concerns about the length of time between court orders for competency-related services and when those services were actually being provided were raised as early as 2011. Due to these mounting concerns, Senate Bill 6492 was passed in 2012. The bill established a 7-day target for defendants to receive court-ordered services. This was, however, not a mandate and was more of a performance goal. At the time the bill was filed, the average wait time for admission to the state hospitals for an evaluation was 41 days. Washington State unfortunately failed to meet that 7-day target. And in 2013, defendants were still waiting on average 29 days for an evaluation and 15 days for admission to one of the state hospitals for restoration services. The 7-day performance target was met less than 15% of the time. As a result, Senate Bill 5551 was passed, which permitted counties to obtain outside evaluators in certain cases. However, reimbursement for those services was limited to $800. And then in 2014, we start seeing the initial filing for the lawsuit. In March of 2015, a bench trial was held in a U.S. district court to define what the court called the precise outer boundary of constitutionally permissible wait times. So first, the court gave their ruling and required the provision of competency-related services within 7 days of the court order, regardless of if this was for jail-based or inpatient evaluations or for the provision of competency restoration. The court determined that 7 days was the maximum justifiable period of incarceration, absent an individualized finding of good cause to continue. They further asserted that 7 days was achievable with more resources and better management, and said a 7-day time period could be achieved within 9 months of the ruling. While Washington began to make changes in order to comply with the court's ruling, they also appealed one aspect of it, specifically the 7-day timeline as it pertained to initial jail-based evaluations. In May 2016, upon appeal, the U.S. Court of Appeals for the Ninth Circuit determined that the strict 7-day timeline for initial jail-based evaluations imposed a temporal obligation beyond what the Constitution required. Interestingly, the court discussed how the determination should not have been based on what is feasible, but instead what is constitutionally appropriate. So they noted how the national average for competency evaluations is 31 days, with 15 states having no statutory deadlines and only 6 states with deadlines under 10 days. The district court later modified the timeline to a 14-day requirement for in-jail competency evaluations. As I mentioned earlier, the state was found in contempt for noncompliance with that 7-day timeline and fined in 2017. They were able to reach the settlement with the plaintiffs in 2018, which required that the state create programming, hire new evaluators, and develop telehealth capabilities. In June of 2023, the state was found to be in breach of that settlement agreement and fined again, this time in the amount of $100 million. The Washington State Senate Bill 5440 was passed to expand diversion and dismissal options for certain charges and to expand agency services for certain diagnoses. So specifically, SB 5440 allows for the dismissal of felony charges against defendants found incompetent to stand trial solely due to an intellectual disability, developmental disability, dementia, or traumatic brain injury, provided they are not restorable to competency. Defendants with these conditions facing non-violent felony charges may not be referred for competency restoration services. In December of 2023, a federal judge also reconsidered and limited good cause extensions, and this allowed for evaluators to receive additional time past 14 days for specific circumstances outside of their control. For example, if the office didn't receive an order in a timely fashion, a good cause extension could be filed. So to incentivize the state to follow the guidelines and the time frame, the court also ordered that the state would be responsible for paying contempt fines when they are found to not be in compliance with those deadlines that have been set. So contempt fines are based on the number of days that defendants remain in jail past the time frame. The purpose of these fines is to prevent further involvement of defendants in the criminal legal system, to reduce the demand for competency services, to minimize harm to defendants by reducing criminal legal involvement in long-term incarceration rates, and to connect defendants to behavioral health services. The court ordered that these fines be used to fund programs that serve the defendants who are awaiting competency services. And some of those programs include co-respondent programs, community support programs, reentry programs, post-arrest programs. They also established the Trueblood Diversion Work Group to oversee selection and performance of these programs. Now I'm going to pass it over to Dr. Rojas, who will talk about the steps Washington has taken to address the settlement.
Thank you. So now that we understand the key events related to Trueblood, I'd like to discuss the steps that Washington took to address the settlement. So in 2015, Washington sought out to better understand the issues that were causing the competency crisis in the state. So first, they surveyed legal system partners throughout Washington state, and they worked with the consultant group Groundswell Services to understand the perspectives of local judges, prosecutors, and defenders. And they did this through focus groups. So with this information, they had a clearer understanding of what was getting in the way of providing these timely services. So we saw some issues with administrative issues, including delays in receiving documentation, a lack of electronic records, scheduling issues, a lack of accurate data and performance reporting. And they were also having trouble hiring and retaining qualified staff, which we'll talk about a little bit later on in the presentation. We also saw that evaluators were having some issues related to lengthy travel times between the different facilities for evaluations. There was also a lack of evaluation rooms at the jails, and sometimes defendants rejected the evaluations, and evaluators also had to wait for intoxicants to clear out of the defendant's systems. So lots of different issues coming up here. In 2015, the consultant group in Washington state worked together the consultant group provided some recommendations, and Washington state actually implemented a lot of them. This included the creation of the Office of Forensic Mental Health Services. And again, this is our organization that works on the competency evaluations and any care and treatment related to competency restoration. The state also increased funding for forensic mental health services. This allowed us to increase the bed capacity and also allowed us to strengthen diversion services for folks experiencing mental illness. They also developed a triage model to identify individuals who are more at high risk so we can get them in the hospital a bit quicker. And then we tried to get more at those administrative issues that we were having. So establishing standards for documentation transmission, standardized court orders to make it more efficient. And then we also provided standards for timely access to defendants and the creation of data systems that forecast future demand and that actually allowed us to monitor the program's performance. And then we also added some satellite stations for evaluators as well. So despite these solutions and programs, as you can see, there were some moments of appeal and contempt orders. And so to try and be as intentional with implementing these programs, it was broken down into 3 different phases. This happened between 2019 to 2025. And so it really was the same exact programs across the board, but we just expanded into different regions as time went on. So once we got to phase 3, we looked at how phase 1 and phase 2 went to see if we wanted to continue to expand those programs. And ultimately we did with those phase 3 regions. And that just finished up in June of 2025. So now I want to take a closer look at what these programs and positions really were. So what these resources really were. We expanded our resources in 3 different areas: people, positions, programs, and places. So when we talk about people, it's important to note that OFMHS is actually the fastest growing office in DSHS. We had 1 staff member in 2015, and we are currently at 220 in 2025. So as you can see, we've grown a bit. A big part of this is actually the forensic evaluator. So since 2015, we've increased from 22 to 89 evaluators. And we'll talk more about what that recruitment process looked like and continues to look like, how we're continuing to try and expand this. But that figure 89 doesn't include 6 contractors that we work with. And it also doesn't include up to 13 trainees that we have each year. This includes 3 practicum students, 4 interns, and up to 6 postdocs. Again, trying to get at some of those administrative issues, we also created the Forensic Evaluator Administrative Support Team. So this included order processors, schedulers, folks who helps us get records as needed. So again, trying to be as efficient as possible with that evaluation process. We also have our diversion services. So we currently have 34 forensic navigators in 8 counties across the state. This program launched in 2020, and their job is really to guide and support defendants who are navigating any competency issues. So they can do anything from accompany defendants to doctor's appointments. They can attend outpatient restoration competency, restoration programming. They can also support them in treatment compliance, making sure they have their medications as needed. And then they can also connect them to housing, employment, and substance use treatment, both while in that outpatient competency restoration and kind of transitioning out. And then one more piece that's important is that they help provide information to the court about how the defendant's progressing through the program. So just providing some added insight. We also have 11 diversion navigators in 6 counties. So this is really to help identify certain individuals who might be eligible for wraparound services. And this is to help break that cycle of recidivism. So trying to hit this issue from all different angles. We also have the Enhanced Clinic Services program at SCORE Jail. This was a pilot program that actually started in 2023, and it allows individuals at this jail to get behavioral health services, so get their psychiatric medications and also some treatment, some therapy. And so in order to get that program up and running, we needed individuals who are willing to support that. And so that was some additional positions included. And then lastly, we have IT resources. So it's not just the materials that we have, like our laptops and phones, but also dictation software, a new scheduling software, and forensic database. So this helps us stay organized and be, again, more efficient with that scheduling process. We also expanded our programs. I've hit on some of them already, but I want to highlight some others. So this includes the crisis intervention training for law enforcement and correctional officers. We also have our outpatient competency restoration program. So this opens up the opportunity for individuals to complete restoration out in the community instead of only being allowed to do that in an inpatient facility. We also have the FPATH and FHARPS programs. These are housing supports for those experiencing homelessness or unstable housing. And we also have peer counselors that are a part of these programs to help connect folks to housing, health, and transportation services. So again, trying to hit this issue of homelessness from different angles so we can support these individuals. We've already discussed Navigator, so I'll jump to prosecutorial diversion program. This allows individuals to go through behavioral health and case management services in exchange for the prosecutor to either not file or to dismiss the charges, as long as if the client successfully completes the program. We also have co-responders, so again, embedding behavioral health supports throughout the community. So these individuals are able to ride with patrol units. And then the last piece is that SCORE Jail pilot program that we've already discussed. So now moving on to places. So this is expanding where individuals are able to get the evaluations done and restoration services. So we have our 2 state hospitals, Western and Eastern state hospitals. A part of those include 518 beds for just forensic patients. So that's been helpful to try and get individuals access to these services. Over time, what the state has been trying to do is open up additional treatment centers so that we can move patients who are civilly committed into those treatment centers and open up more forensic beds within the state hospitals. So some examples of that include Maple Lane campus. This initially served competency patients in 2016, but it currently serves individuals, civil and NGRA patients. We also have the Olympic Heritage Behavioral Health Hospital. This opened up in 2023, and it also serves civil patients. And then lastly, we have the Brockman campus, which we were hoping to open up in 2025, but unfortunately, due to some lack of funding, we weren't able to do that. That being said, the state did provide funding for a warm closure, meaning there's funding to maintain the campus and building. So hopefully we'll be able to open that up later on. And then the last piece is the community behavioral health centers so that individuals can go through outpatient competency restoration programming, again, out in the community, and not just have those options available in the state hospital. All right, I'll pass it off. Thank you.
All right, thank you, Dr. Rojas. So you've heard a lot about the changes that we've made. So how has this affected our compliance with the Trueblood requirements? So as seen here in this table, you can see that the state has made notable progress in complying with Trueblood's orders in the last 10 years or so. So as seen in 2015, an average of only about 12% of jail-based evaluations were being completed within 7 days of the court order. This number rose to about 44% being completed within the 14-day completion window in 2016. And fast forward to the last year or so, in 2024 to 2025, this number is at around 91%. So 91% of evaluations within jails are now being completed within the court-ordered 14-day window, which is quite remarkable when you look at where we were 10 years ago. A similar trend can be noted within our inpatient evaluations and the provision of restoration services. So as seen in 2015, those numbers were dramatically lower, rose a little in 2016, and now you're seeing compliance rates in the 94 to 96% range. Similarly, a large part of our compliance efforts has involved the creation of these outpatient competency restoration programs, which Dr. Rojas mentioned. And in phase 1 and 2, these OCRP programs became available in 11 counties and 4 additional BHASO regions. And then in phase 3, between August and October of last year, 5 additional counties and 2 additional regions began providing these outpatient competency restoration services. And a 3rd facility just opened in August of this year. So this is helping us reduce the demand on our inpatient facilities by increasingly treating patients for restoration in the community. Now, how have we been able to expand as an organization and a workforce? I'll hand it over to Dr. Stillwater to answer that.
All right, thank you for that. So we've talked a bit about what Washington has done to address the settlement and how these changes have impacted settlement compliance. Now we're going to look a bit deeper into how we've been able to expand as an organization and a workforce. So we'll start off by talking about the recruitment and retention of evaluators. And so this cycle here really utilizes a developmental model of training. It feeds into a self-contained cycle of high quality provision of services and the continuation of skill sets in early career psychologists. So starting with the top left part of the cycle, this is the presence of psychology trainees at all levels. So thinking practicum, internship, and the postdoctoral level. This increases staff engagement in the services provided and the application of psychology in the legal system. And then that second phase of the cycle is well-resourced training programs that draw high-quality licensed staff who continue to teach the next generation of professionals. And then segueing into that final stage of the cycle is that psychologists have opportunities to give back to the profession and continue honing in on skills to ensure competency. And so you can really see the developmental model here of starting off by honing in on those skill sets and areas of professional development among incoming trainees, and then them growing into career psychologists and being able to provide those services back to trainees. And so I do want to address, in 2022, there were some staffing challenges that OFMHS faced. And so steps that we took as an organization to address these challenges were included hiring more contractors and travel nurses. We added hiring recruitment resources to both Western and Eastern state hospitals, especially to hire nurses. We also partnered with the Washington State Office of Financial Management to adjust pay ranges for certain positions. We expanded our successful forensic evaluator training program, and we bargained with labor partners to allow for contract evaluations to take place until vacancies can be filled. And so another big help with recruitment overall has been that OFMHS offers opportunity to conduct evaluations remotely. So we have a large number of evaluators that are in different states throughout the nation that conduct evaluations. So we've been able to recruit a lot of very highly skilled evaluators, also for non-permanent positions as well, to fill specific needs within an organization. So talking about employee engagement, so training programs include the retention and recruitment of potential employees, which benefits agencies and facilities. So consistent with current theories of workplace engagement, engagement in training programs can provide an employee with additional motivational factors of achievement. And so increased employee engagement and investment from supervisors can increase the likelihood of retaining well-trained professionals. So trainees feel valued and they tend to desire to stay within the organization after completing a training program. And specifically when looking at our postdoctoral fellowship program, fellows are prepared to enter into the organization as a forensic evaluator immediately upon completing their training. And when organizations are known to invest in quality training programs, this can also attract applicants. And so OFMHS is a very reputable, well-known formal postdoctoral fellowship program that receives applications nationwide. And so when trainees know that the investment continues on past that training program is critical. So for example, knowing that there are opportunities to secure various roles within the department and the various teams through OFMHS is invaluable. And so over the last 40 years or so, OFMHS has conducted sort of an ongoing illustrative case study and has found the following 4 markers for successful programming. This includes administrative support, clearly defined and meaningful training opportunities, mentorship and cohort effects, and competitive salary and benefits. And so for the purposes of this discussion, I'm just going to focus on evaluators since they are the backbone of the competency evaluation process and completing those evaluations. And as was discussed earlier in the presentation, with the increase in the number of competency referrals, finding high quality evaluation staff has been crucial to complying with the Trueblood lawsuit. And so we'll start off with administrative support. So organizational support at the administrative level is crucial to a thriving program and a culture of engagement and workplace learning. And so at OFMHS, there's clear communication and understanding that productivity is not an outcome goal of training programs. And that's been really indispensable because there isn't pressure on postdocs to complete, for example, a certain number of reports per year, but it's really about that cultivation, that development of professional skills to be able to continue on in the field as an evaluator. And so the single most important critical factor to be understood by executive level administration is that a training program pays off in 2 years with new staff. And so it doesn't pay off immediately with the less expensive labor of a trainee, but effective training programs can provide a pathway to build out long-term outcomes, not short-term fixes. And so while not always the case within DSHS, once the training programs were moved fully under OFMHS, the recognition of the long-term investment model by executive management really allowed for the creation and growth of a comprehensive training program, and it more effectively utilized the increasing number of licensed psychologists within the agency for high quality supervision in the forensic setting. And so, for example, following fellowship year, trainees are now able to independently contribute services to the court as a result of the extensive training and supervision that they received. And then they can now provide supervision to incoming and aspiring trainees as well. So that kind of speaks back to earlier when I was talking about that developmental model of training. Really, the cycle just continues and continues. And so when looking at cohort for learning, so OFMHS trainees across the state have contributed to a cohort that can learn and grow from each other while experiencing mentorship at a developmentally appropriate level. So individuals who go through the cohort together and go through the program were able to continue building those relationships as evaluators. We're able to continue to seek mentorship and consultation. And even with people that have previously supervised us as trainees, we are now able to consult with them as colleagues. I think it's a really invaluable experience that those relationships continue to develop over the course of our careers. And then finally, competitive salary as that fourth prong. So trainees were shifted from contract employees with low pay to clearly defined learning roles and subsequent positions within state service. And this early investment appears to have paid off for the agency quite well, as over 75% of trainees, specifically internship and postdoctoral trainees, have worked as psychologists for the state of Washington for at least 2 years post-training. An important part of the investment strategy and the recruitment process is the allocations of funds and competitive salaries to help retain quality evaluators, which will be expanded upon in just a couple of minutes here. But a clear retention shift was found after a foundation was supported by the agency of providing close supervision of practice, supporting the time required for the development and monitoring of individualized training plans, and the creation and maintenance of an intensive didactic training schedule for all levels of training. And this includes topics such as clinically focused areas, forensic evaluation and specialty topics, assessment techniques, and case law. So now I will pass it back over to my colleague.
Okay, so how do we continue to prioritize program and workforce growth here at OFMHS? So some recent Trueblood accomplishments we want to make note of, as my colleague Dr. Stillwater just alluded to, current forensic evaluators are experiencing increased salary ranges. So on July 1st of this year, their salary range increased 2 salary bands, and most employees also received a 3% cost of living adjustment effective July of this year. And effective July of next year, most are scheduled to receive an additional 2% cost of living adjustment. So really, we're trying to compete with other states in a way to attract high quality forensic evaluators. If we have any forensic evaluators in the room from other states that might be listening, just something to make note of. We are continuing to recruit to address high vacancy rates in critical patient-centered job classes beyond just forensic evaluators, looking at professions like nursing, forensic navigators, things of the sort. So our outreach team continues to work on filling those positions for the additional facilities that continue to be built. And this is just a quick note to demonstrate that despite facing revenue shortfalls, our state legislature has been able to fund additional projects in our 2025 to 2027 budget, including things like $22 million to support the expansion of the Maple Lane campus, which, as Dr. Rojas noted, treats civilly committed patients, to include Olympic, Pacific, and Rainier units. In addition, providing additional funds for the Maple Lane campus for 16 beds in the Chelan unit. You can kind of read through this in your own time, but as you can see, we're adding a new 16-bed crisis triage and stabilization facility. And it's essentially just a indication that even though we have faced budget shortfalls, this continues to be an area of prioritization for us. So looking to the future, ongoing considerations with respect to the Trueblood lawsuit, one piece that we have become dedicated to really addressing is treating individuals earlier in the pipeline prior to any kind of psychiatric decompensation or involvement with the justice system. So this is really important for the Trueblood context because the lawsuit was also about the systemic failure that led people with serious mental illness to cycle through jails instead of receiving timely care in the first place. So our commitment to this has been the funding of additional programs that were mentioned earlier, like FHARPs, FPATH, and forensic navigators that provide things like supportive housing, case management, peer recovery services, and treatment for people with behavioral health conditions at risk of legal involvement to really address this problem before it reaches our offices, before it reaches the competency stage. Additional considerations involve providing immunity for evaluators when they are prevented from asking about possible symptoms due to things like the patient refusing or having to wait for intoxicants to be cleared, those types of delays that were mentioned earlier, to reduce additional scheduling delays and the need for reevaluations. In addition, we're looking at providing additional solutions to reduce the number of competency referrals, perhaps by eliminating misdemeanor evaluations from the get-go. We are continuing to increase our diversion efforts, particularly in King County, where Seattle is located, as this is the region with the highest referral rate. And then finally, just continuing to invest in workforce development for forensic evaluators and the training programs to provide ongoing didactics, peer review, training seminars, and education for our workforce. Yeah, as we've noted, that has been a big piece of our organization's success over the years. So that is it for us. We thank you for attending our presentation. We're happy to take any questions. In addition, all of our data is public. You can refer to these websites if you would like more information. I believe that they have appendices that have detailed the data since 2015 or so. So thank you again.
Thank you so much, everyone, for that helpful overview of a lot of the things that have been going on since the Trueblood case there in Washington State. You, of course, are certainly not alone in a number of different states here that have been dealing with a lot of demand and need for competency evaluations in an orderly, timely manner. So thank you for sharing with us all the involvement in your state, and hopefully many other states that have also struggled with timeliness can follow as well. We do have a number of questions here already in the chat box. Feel free to ask any questions from attendees as you see through. Well, I'll go ahead and throw some out to our panel right now. Unless they suggest otherwise, I'm just going to be throwing these out to you. So whoever feels comfortable responding, you can have at it. So one question that came in is, in general, for your area, where exactly are these civil treatment centers? How spread out are they over Washington State? I know several states have had, these resource issues, but then also trying to geographically distribute equal access across states. So I think this is a curiosity of where these civil treatment centers are in your state and how they can access different areas geographically.
They're spread across the state. So they are in mostly major metropolitan areas, but then also attached to locations where people can get to. So I-5 or I-90 corridors, areas that both the defendants and the evaluators can get to, as well as the treatment providers. So Seattle, Tacoma, down in Vancouver, over in Spokane. So they're just kind of spread all over the state.
Was the 14-day deadline just for outpatient evaluations, or did that apply to the inpatient evaluations as well?
I'll just answer all these questions. So the 14-day deadline is really for individuals who are in jail awaiting services. So the 14 days specifically speaks to individuals who are in jail waiting for an evaluation for competency. So sometimes people describe that as an initial evaluation for competency. And then the 7-day timeline applies for individuals who need to get into the inpatient setting to receive evaluation or restoration services. So there's two kind of different timelines. One is the evaluation piece when somebody is in jail. And then the second is when somebody needs admission to a hospital, and that's the 7-day piece.
And roughly from your understanding, I guess over the past 10 years or so, how many people are found not competent to stand trial, or excuse me, how many people that were found not competent to stand trial ultimately are civilly committed?
We don't have the exact numbers for that one specifically offhand. It fluctuates over time, and it seems to match with community funding and diversion services. So when it's not only the finding of the evaluator, but also are there services available to essentially stop the pursuit of the criminal case and go towards maybe civil commitment or some sort of resources that can be invested into that individual instead of competency restoration specifically. And that waxes and wanes with bed space, with just the individual prosecutors and defense attorneys, and then also with resources in the community and in the hospitals as well.
Last week's law and mental health speaker, Dr. Ira Packer, thank you so much again. He asks a question noting that there was significant improvement in that 14-day compliance from 2015 to 2025. They thought you said that in 2015, the requirement was 7 days. With that in mind, do you have data on the average time now for completion compared to 2015?
We do. I don't have it off the top of my head. It is in that compliance rate, if anybody saw that.
Yeah, the number that was listed in that table referred to the 7-day window in 2015. So sorry, I didn't specify, but there were subscripts denoting like 2015 was 7-day, 2016 was 14-day.
Wonderful. And all those that have registered will get copies of those to be able to look at those graphs as well. So thank you for that. Roughly, what is your rate of felony versus misdemeanor evaluations these days?
I think we had a slide on that. Any of my panel members remember the exact distribution? More misdemeanors than felonies.
I don't remember the exact figure, but it's more misdemeanors than felonies. And so that feeds into our potential solution of how can we try and reduce the referral rate, and maybe addressing the misdemeanor piece can be helpful with that. So we're continuing to problem solve around that.
And I think anecdotally, what evaluators see on the ground is, repeat arrests for things like trespass or stealing merchandise that's of low value. And we see that that's the entry point into the mental health system in Washington, which I think drives some of that open door or revolving door process that we're seeing with our referral rates as well.
Wonderful. I do see a series of questions that get more specifically about some Washington state evaluation issues, given that you did say we're looking for people and we're always growing. So some of these questions are more about the logistics of doing forensic examinations in Washington. I'll throw a couple of those out there right now. What are the caseloads typically for state employees? How many evaluations are typically expected or scheduled a week or month for evaluators?
Yeah, in practicality, we try to schedule 3 interviews for defendants. So sometimes a defendant will have multiple cause numbers open at the same time, but you get the single interview. So 3 interviews each week for evaluators is the pace that we'd like to see. Sometimes it's more than that. Sometimes it's a little bit less than that in the fluctuating referral rates. However, our evaluations are very focused. We're just answering the competency related question at hand. So we're focusing on relevance and the here and now evaluation of competency only. So we get evaluations that are about 7 to 10 pages. And if we're looking at more than that, then it's probably a pretty complicated case that might take some more time that week. But typically about 12 evaluations per month is what evaluators do.
And I know this question, this varies widely in New Mexico, at least depending on particular districts, but somebody asked, typically how often are people asked or expected to testify on cases that they evaluated?
Depends on how well you did that report. No. It's often really variable just based on what the defense or prosecution, what argument they want to make. So we're seeing an increase in number of inpatient evaluators that are asked to speak to restoration or restorability. And I typically do not testify very often just in my own practice. And so, outpatient evaluations may be a little bit less than that right now. Just the courts are trying to churn through those initial competency evaluations and then have more time to kind of formulate arguments or different strategies or ways to go with the case once they're inpatient. So I would say I testify maybe 6 times a year, but I know there's other evaluators that testify once or twice a month at times, depending on their location. King County, for example, is a little bit more litigious than somewhere like Spokane County that may take the word for the evaluator from the evaluator a little more readily.
Before I continue to ask these questions, I just wanted to alert all our attendees in the chat box is the link for the CEU survey for those of you that are pursuing APA continuing education credits. On the screen now also is the QR code if you want direct access to that survey link as well for those that want APA continuing education credits. What are the educational or experience minimum requirements if somebody wanted to enter Washington as an evaluator?
Licensed psychologist is the main base that we have. What we see is that we need very focal, experienced individuals who know how to navigate the legal system in a quick and efficient way. And usually that is acquired then through additional education and experience in the forensic mental health system. So as a postdoctoral fellow or as an intern in a forensic setting, those really lend to a competitive candidate for us. And we often have more in-person positions than we have even postdocs per year. So we try to look at each individual candidate as they fit within our system and as they can be successful within our system with the experience they have.
Several questions tying to the very similar issue of compensation rates. So any compensation data that you'd be willing to discuss, and then someone also had a general question of does the state find evaluators more cost effective, full-time evaluators versus contingent part-time contracted evaluations or vice versa?
Yeah, I think we have been on the let's just fill the vacancies route. So I don't think anyone's really stopped to really analyze the nitty gritty of, benefits with a full-time employee versus contractor versus we just really want to get the evaluations done so that these individuals can move on, so that the court system can get their job done, and so that we can get that accurate forensic mental health information to the court as quickly as possible. But within our system, I believe $150,000 is kind of the starting, and then goes up from there. I don't remember the exact. That's also public data. If for interested parties, they can certainly email me or find that information on the recruitment website for Washington State. But that we're trying to keep up with the demands, and as other states raise their salaries, we encourage the same here, just for the high amount of evaluators that we need for a mid-sized state. That evaluation rate of referrals just keeps going up, and so we keep needing to stay competitive with that salary.
Fair enough. Thank you for that information. With the issue of timeliness being discussed, somebody asked, for your state at least, how quickly are you able to receive records, and have you done anything that has been able to fast track that process? I know that is something that has been quite a challenge here in this state, in New Mexico.
That is a huge area of growth that we've done, and part of that kind of administrative support package that we have been working on over the last 3-4 years. So we developed a forensic mental health records team that is exclusively for trying to get records in a quick way, and then because it's dedicated to us, has that time to try to build those relationships and communication pathways with those high referring or high need places like certain medical or mental health facilities that we frequently request records from. And those types of records. We're, again, because we're so focused on relevancy for the competency piece, we're really just looking for those here and now records, what will make our decision now. And so we're not looking necessarily for school records or long-term care records, but those records from jail mental health staff and recent community mental health contacts. And so that's what that team is really focused on getting. So we get a turnaround now closer to 3 days for records versus sometimes months that we had previous to that team when evaluators were trying to reach out on their own ad hoc, and that just really didn't work and was not efficient in any manner. So
absolutely, yes. Thank you for that information. Somebody noted that you gave information about the number of evaluations needed. They said, of course, population increases over time. Is the percentage of evaluations that's requested now different than in prior years? If there's an increase in how many defendants are being requested for an evaluation, from what you're understanding, what factors are causing this increase in competency referrals?
Any of my panel members want to jump in? Yeah.
So it's definitely been increasing over time. And I believe there was a study that OFMHS actually did that looked at reasons why people ask for evaluations. And sometimes it's actually seen as a way to connect people to behavioral health services. And so that is not necessarily the entire point of a competency evaluation, but it's seen as that. So people may see, attorneys may see that their clients are struggling or really navigating mental illness, and it may be a way to connect them to services. So that's one piece. Jackie, I don't know if you have any other components. And then also like the increase in misdemeanor referrals, those are continuing to go up again. So those are connected to some solutions that we're looking at to try and reduce the referral rate. And then third, the recidivism rate, and just kind of getting back into our systems and not necessarily like having access to those behavioral health services prior to, this competency issue coming up. So it sometimes ends up just being a competency referral.
Someone asked if you have any data to support the effectiveness of the outpatient competency restoration.
That's newer. And so they're running into typical problems like substance use when somebody's back into the community, or unstable housing situations, even with the support of the navigator in those situations. So I think those are kind of common sense or typical issues that those programs are running into. But we're also running into some deficits in training for the community programs, where it's more of a community mental health lens that they're looking through for treatment. If somebody wants medications or, treating anxiety or lower level symptoms and not seeing the delusions and maybe competency related barriers that are happening. And so that aggressive mental health treatment, especially with medications, is not as prevalent in the community programs as we'd like to see. And so that ongoing education has really been an important piece of our service as well, to just communicate that need, both in the evaluations and to the court and to the programs themselves. So I think that's a huge growth area, but we don't have specific numbers yet for competency versus incompetency rates or who completes the programs. That is still in progress.
Fair enough. Thank you for that. As we're reaching the top of the hour, somebody had a question. I know you did mention remote evaluations being an option. Someone asked about physical presence there, but I'm going to take a little, I'm going to add to the person's question, given some issues that we've had here in the state. They asked, do the evaluators need to be physically present in Washington to help out with the evaluations? Are there part-time options? I'll add, what is there in place if somebody is doing an evaluation remote, but then wants to do testing that would require an in-person meeting?
I can actually answer this question. I am remote evaluator. So I actually live in Colorado, but I work for Washington State. And so we're able to do the evaluation remotely. And so if there's any testing or additional questions that require testing, that can be done by a psych associate, which is really helpful. And so sometimes it's when we think about standardization, if we have to do testing remotely, that we can run into some issues there. But that's something that we're continuing to develop, is how can we use the psych associates to really complement our work and support us through that process to get that additional information that is going to be really helpful to coming to your opinion. And then, yeah, we have people coordinating the telehealth, like more of that administrative piece. We have people coordinating those calls. So it's not on the evaluator to do the scheduling or to connect with the attorney. That's already done on the front end. So you can just focus on the evaluation at hand.
I can speak to the I do in-person inpatient evaluations at the hospital, but we also have a team that just does strictly telehealth inpatient evaluations, and so there the hospital is really helpful in getting all of like the logistics set up, like the computers and technology and all of that, and so we are able to do both in-person and telehealth evaluations specifically at the hospitals too. And then like Dr. Rojas said, if there's testing that's warranted, either the in-person evaluators will, if they have time, will conduct that, and or we have postdoctoral fellows and or interns that can also help out with that process too.
Also, I think it's important to know that this is a continuing area of growth where I work on the PR team, so it's more people in the community versus if I were on a team that does in-jail evaluations. Some of those can be done remotely. Some can, some jails are more set up than others for those telehealth services. So that's something that we're continuing to trying to expand on that.
Yeah, and I think too, Dr. Means, you had alluded to, I think last year when we were postdocs, about how some of the jails don't really allow for or make telehealth evaluations very, very challenging. So we oftentimes will have to do in-person evaluations for those to offset some of the barriers there. But so some, like Dr. Ross was saying, a lot of barriers that we're experiencing, but also finding ways to navigate that as well.
And as we wrap up here, I'll note that a psychologist on your team added, as people were asking questions about salary. If you want to see different salary ranges, you can visit the Office of Financial Management website for Washington State, looking up the job classification for psychologist forensic evaluator. So again, thank all of you, Dr. Rojas, Dr. Stillwater, Dr. Monjazeb, Dr. Raysor, Dr. Means, for all the work you're doing in the state and for sharing the unique and unfortunately not so unique context of competency evaluations in Washington State and everything that Washington has been doing over the past decade or so to address these time-sensitive and very critical forensic evaluations. So thank you so much for sharing all of that information with us. And that does wrap up this week's Law Mental Health series. Next week, we have Dr. Susan Hatters-Friedman, who will be discussing public health issues regarding maternal filicide. We hope to see you next week then for another great discussion of issues in behavioral health and the law. Until next time, take care.